The Family Law Act sets out the rules and guidelines for the division of assets, liabilities, and superannuation entitlements when a marriage or de facto relationship ends. This includes the treatment of any property that may have been disposed of or wasted during the course of the relationship. The term wastage refers to when a party to a relationship intentionally or recklessly or negligently reduces the net property pool available for distribution between the parties during the relationship or after separation. One of the leading cases in this area is the case of Kawalu. In this case, the court was asked to consider whether the husband's waste of a matrimonial asset during the course of the marriage should be taken into account when dividing the property. The court held that waste is a relevant consideration when dividing property, and that a party's waste of the matrimonial assets can impact the division of property. Some examples of wastage acts include spending money on non-essential items such as luxury vacations, expensive cars or jewelry, gambling or prostitution, selling or transferring marital assets without proper reason or consent from the other party, the destruction or neglect of property such as neglecting home maintenance or not properly caring for a business, incurring debt for non-essential purposes such as taking out loans, gambling or making unwise investments, and finally, disposing of assets in a way that deliberately reduces their value, such as selling a property for less than market value. If you suspect that your former spouse or partner has wasted matrimonial assets, there are a few steps that you may take to address this issue. For example, you may wish to seek that the court makes an injunction order that requires a party to refrain from doing a specific act, such as disposing of asset or incurring debt. Another option is to seek that the court makes a Section 106B order that enables the court to set aside a transaction if that transaction may defeat an existing or anticipated property settlement order. It is important to note that not all wastage is considered equal, and the court will consider circumstances surrounding the waste, such as timing, purpose, and extent of the waste, when deciding how to divide the property. Additionally, the amount or asset that has been wasted by one party may be added back to the net property pool to ensure that there is a just and equitable division of the joint property pool between the parties. If you have any questions or need legal advice with respect to wastage and how they may impact your property settlement matters, please reach out to us for a confidential consultation.